Hey, Michael.
Hey, how you doing?
Good, good.
Our last video we did was on property boundaries and all the problems and such that people get into. Questions came in about fences, so here we have Steve Gaynor back to explain to us issues with fences. Do you want to just start? I'll ask you questions, or you just want to wing it?
Well, are we on?
Yeah.
I just want to point out that I'm wearing another tie today, so everybody can appreciate me.
Yeah, you came back. Yeah.
That shows respect for all the viewers out there.
That's
and
hard
for
to
you.
get respect for an attorney. Yeah.
I know, very hard. It's hard to get
It's all in the tie.
It's hard to get a new tie for an attorney. Nobody wants to sell you one.
Unless it's this way.
Right.
Okay.
You know, the same kind of outside issues come up, which is that a lot of times people fighting over fences have other things on their mind, that they didn't get invited to the neighbor's
That's why
wedding
they put up
party.
fences in the first place,
Yeah.
to keep people out. Yeah.
Yeah, but then they also have all kinds of resentments sometimes, and it makes it even worse instead of just talking about the fence. But you know, fences do raise issues. I think one question you asked me earlier was about fences that are on the line
Or not.
or not.
Yeah.
If we talked about boundaries, and one of the big problems that comes up, which we won't go into again, is that sometimes somebody builds a fence on the other person's property. And then you got a boundary issue. Your fence doesn't belong
Right.
there.
Yeah.
Or you have a question of have you now developed a right to keep the fence there? Has it
So
been
where
there
they have
so
a
long?
handshake, it's not worth moving. Let's just leave it.
Yeah.
Yeah.
Well, we talked about that last time. That's with two neighbors who like each other
Uh-huh.
and say, oh, let's just leave it. Let's not worry about boundary lines. In fact, I think I have that situation myself with a nice neighbor. But then one of the nice neighbors moves.
Mm-hmm.
Someone else comes in and says, hey, your fence is on my property line. And so that becomes an issue like we talked about last time, a boundary issue. If you have a fence on your own property, we can talk a little bit about something in a while called spite fences, but basically that's your business. You have to maintain it and you can keep it there. There's no issue. Nobody can,
So if you're like an inch over on your property,
You're
line,
all set.
You can do what you want.
but
Okay.
you have to maintain it. Now, I'll mention what's interesting, if you're only an inch over, then the question is, do you have any right to get on the other side to fix your fence? That's a problem. But when fences are right on the line between two boundaries, then the law is, and usually that happens because people agree to build a fence together, then the law is they both have a responsibility to keep and maintain the fence. Now, there's an exception if one person can say, hey, any benefit I get from the fence financially is completely outweighed by the costs of fixing the fence, repairing it. But, you know, the minute you get into that, you know, you're talking fuzzy concepts and you're asking for a lawsuit and going to trial. Because, you know, what does it mean really to say that something that it's going to be more burdensome for you to fix the fence
Right,
than to
yeah,
get benefits? So, but that is something you can, you know, that comes up with a fence that's right on the boundaries. And there are a lot of situations like that. If they're on the line, that's a situation. Both people are responsible.
But how do you enforce that? I mean, I run it all the time. New buyer moves in, they got 2 out of 3 fences are brand new. They want to put a third one in. The neighbor goes, no, I'm not paying for it.
Well, the answer is you can't make them pay for that new fence. You put it on your own land.
Okay.
So the fence on the boundary, that rule only works when they both agree to put it up, and then the question is who's going to maintain it?
What if it's already there in the first place?
That's a good question, and then you get into, again, kind of a fuzzy area about if you had to go to court saying, did the person buying the property realize that the fence was on the common line and that had to be done? And guess what? Now maybe you go in there and bring in the poor original seller and say, you didn't tell me, you didn't let me know, I didn't realize. A good reason why they need people like you that make sure those issues are thought of ahead of time.
Well, that's my standard disclosure is
Exactly.
that fences may or may not be on the property line, but that doesn't really do anybody any good. It just gets me off the hook. So that's why we're having this discussion, so they can, you know, at least know the questions and issues when they get into a property. And there's a fence with a neighbor, at least you know what you're getting into.
Well, and the other thing, interestingly enough, is you again, we talked about this, is you can get title insurance with an extra addition called the rider, which will do a survey.
Right.
So you know ahead of time, wow, this fence is right on both property lines. Or it's on the other property line, but if it's on both, you know ahead of time you've got an issue about having the responsibility to share that cost. And that, that's an issue. So the other thing we can talk about is the spike fence.
I've never heard of that before. I can imagine what it's about.
Well, it's really, to put it in shorthand, because the legal gets to be about 4 different tests, but the shorthand is, it's a fence that the builder doesn't really need for any purpose that a court is going to...
property owner who's going to build the fence.
Yeah,
okay.
the property owner doesn't really need it for any purpose that a court will say, I see why you
Okay,
need it.
right.
Again, you're going to be going into court with that. And it's the other person on the other side that's suing you. They're saying you don't have any need for a fence that tall. The rule occurs when the fence is over 10 feet tall. That's a hard.
Okay,
That's the
yeah,
one thing
yeah.
we can. The one thing we can do in this area of law, because so many areas of law end up depending on what a judge thinks or a jury thinks.
Reasonable.
Yeah, they're not certain.
Yeah.
The one thing we do know, it's a fence over 10 feet.
Okay.
So that's easy. All we need on that part is a ruler. But if it is over 10 feet, then we have to say, does the owner who built the fence on his or her land have a reasonable basis for needing it? There we go with the magic reasonable,
Yeah,
which means the judge has to look at it.
Right.
And then the question is, or if it's not a reasonable basis, did the builder, the owner, build the fence merely to spite the other person, merely to make them unhappy and miserable? And then the question is, how much of the value of the other person's property is ruined,
Damages.
damages
Yeah,
by that
yeah.
fence? And as people know who have already been with us a bit and catch on, you're just looking for a big game for
Yeah,
lawyers,
yeah.
because each of those issues, other than the height of the fence, is not clear. You're going to get in front of a judge, and the magic word that lawyers often use is fact specific. In other words, you got these nice little formulas with words, but in the end it depends on the facts. It depends on a judge or a jury looking at this and saying to the owner who built the fence, I just don't think that your argument that you built the fence because you love fences or you love dead redwood trees built into fences is going to match the fact that you've had this long fight with your neighbor, and your neighbor now can no longer see the moon rising, or can no longer see the mountain in the distance, and that impact is very annoying. And to try to measure it, we bring out a property appraiser. Boy, is that going to cost money. And the property appraiser is going to tell us, guessing frankly, that now the value of the person's land, the person suing, has been reduced by $50,000.
Yeah, and then we challenge the appraiser because who's paying for them? Of course, we used to call made as instructed.
Yeah,
appraiser.
exactly. So now we have a big fight over is any potential buyer now going to pay $50,000 less because that fence is
Right,
there?
yeah,
We don't really know that.
Yeah.
And anytime you get into these things, the only way you really know damages, as opposed to what an appraiser says, is what finally happens in the marketplace. There's somewhere out there so the point I'm making is that it's very subjective. And somewhere out there somebody's going to say, I never wanted to look at the mountain. And in fact, I kind of like that fence. We don't know that right here. So the appraisers have to do a guess. So that's the spike fence. And that kind of moves us into the area of trees. Because the interesting thing is, and I want to make one more point too, the fact that a fence is blocking the view of a neighbor, and it's the same thing with trees, that in itself doesn't give that poor suffering neighbor a grounds for a lawsuit. There's no right to a view, or to air, or to viewing sunlight, or looking at anything. There's no right under California law for a fence. That's the statewide law. Now, on a local level, the city may have an ordinance. In fact, interesting enough, cities generally don't allow a fence greater than 6 feet high with an 8-foot mesh or trellis. Anyway, so that's the interesting thing is you'd have to be out in the countryside usually to worry about a 10-foot fence, because most cities in California don't allow a fence in their zoning code larger than 6 feet plus a 2 feet mesh. But then on the idea of the view, cities may prohibit blocking a view. It's in their zoning ordinance. Or if you live in a planned unit development, which is kind of a condo with a lot of houses instead of apartments, they may have a rule that everybody is assumed to be governed by the minute they buy the property. And the rules are in what's called the covenants, conditions, and restrictions. And the minute you buy something, those covenants say that it applies to anybody who buys that property. And if a broker, certainly not like Michael, doesn't tell somebody that, the broker's in trouble. Because that is the rule. That's how you bind them. The minute you buy it, you're stuck. And, another reason that you're assumed to know this, which is very interesting, is, and I'm sure you realize this, the covenants, conditions, and restrictions are filed with the county recorder. So that means that there's an interesting law coming in saying everybody is expected to go there and look.
Well, it's actually provided to them at the sale.
It should be by a good broker.
Whether they read it or not, no, it's required pretty much.
Yeah, but whether or not that happens, you are expected yourself as a buyer or through your broker to be aware that these things have been recorded. So they're filed so that when you look at your property and it says 123 Angel Street in this subdivision, if you go and look that up, it'll say subject to covenants, conditions, and restrictions on file. And you have to read all 50 pages, or you're expected to.
And it may or may not have something on fences.
But if you don't read it, it's tough luck. That's an interesting side issue. The fancy word for that, remember we talked about the word constructive in law, which is that the court says we assume something. So people buying property are assumed to have read everything governing that property. Doesn't matter whether you did or not, you're assumed to.
Right.
And that's kind of a neat scheme because basically the buyer's stuck with whether he or she read it or not, and their broker's stuck with making sure you told people you better look at it. So the covenants and restrictions may prevent fences of a certain size, and so that's there. And the other thing coming in is the new thing with solar devices. And again, if someone wants to install a solar device, it's not in yet. I think you can give notice to your neighbors, and then they can't block that solar device as to new things they put in.
Right. Yeah.
And that's California law, so we know that. So that kind of turns us to trees. And one interesting thing about trees is someone can go outside and build a fence, and you really knew what they're doing. Trees kind of build themselves. So we get into an interesting area of the view rights for trees. And again, it's exactly what I said in terms of fences. There's no California law saying that anybody has a right to a view and can stop a tree from being built. But most cities in picturesque areas, Tiburon, California, Mill Valley, California, many areas in Marin County, possibly the East Bay, have rules saying you can't let a tree grow to block your uphill neighbor's view of the bay.
Well, each little town and city have their own.
Yeah, so you go to their local rules. Or if you're a planned unit development, we talked about it a minute ago, the covenants, conditions, restrictions may say that. And there's lots of lawsuits involving people in these planned unit developments who say, I would just love a row of cypress trees lining my beautiful backyard. And then the Association of Owners Governing says, no, you can't. You're blocking everybody else's view. So that's, again, that comes up. And then the solar issue again comes up. And if someone wants to build a solar energy collector, they notify their neighbors, and then the neighbors cannot bring in a new tree or let an old tree grow so as to block that view. Lots of fights over trees because, very often the downhill person just lets their tree grow. It's been there for a long time. And the interesting thing about trees is that one person's heritage tree is another person's view blocker, nuisance,
yeah,
etc.
yeah.
It's really funny. So it's very, we'd say it's very subjective. And bitter fights over this. Someone loving their baby redwood that's growing and someone else saying you're blocking my view of the hillside. So that's interesting. Then we get into other issues about trees. For example, if a tree is on both people's land, it straddles the land, it belongs to both of them.
Doesn't matter who plants it?
No matter who plants it.
Okay.
And that's a good question. I can't firmly answer that. That's a very good question. That would be interesting. And maybe maybe one owner could say, I didn't ask you to plant that, why'd you do it?
Yeah.
It belongs to both. And what I'm not sure of now is whether either of them can therefore cut the tree down. I don't have an immediate answer. I do know that they're both responsible for taking care of the tree as long as it's there. Same with the fence rule. What happens a lot is a tree, in terms of the whole trunk and the major roots, are on one person's land. Then the branches go over to another person's land. That other person has a right to cut those branches as long as they don't damage the tree.
That's subjective again.
Well, you've been not only a great broker, but such a great law student. What's the magic word that comes in?
Reasonable. Yeah.
Reasonable. They have to be reasonable in cutting the tree.
And how much can you afford to be reasonable?
What bothers lawyers is when you have brokers like Michael, because after a while you think they may not need a lawyer, which gets scary. Then the lawyers are out of business.
I don't practice law. I do it for a living.
Right. But anyway, that's the issue. With roots, it's the same thing. The person on the other side of where the tree is located has a right to cut the roots that are causing them problems, but again, they have to be reasonable.
They can't damage the tree.
They can't damage the tree. Now, we get into a very interesting issue if the tree is pulling up the foundation of that person and saying, I got to do something. Arguably, that's reasonable. And I hate to say, it's interesting as a lawyer, but the thing that everybody is stuck with is to be safe, they probably have to go, if they can't work it out, they got to go to court. Because you would like a judge to put a blessing on you and say to you, okay, you've got a right to cut it. And again, it can be a gorgeous tree, and an appraiser hired by the person on whose land the tree is, the fundamental roots of the tree are growing, can come out and say, my God, that gorgeous, gorgeous chestnut tree is now dead, and in my opinion, people would have paid $50,000 more for that property with that chestnut tree there. So you're better off heading that off by going to court. And it doesn't mean that you have to sue for damages. If you jump in early enough, you sue for something called declaratory relief. You go in and you ask the court to tell you whose rights and whose obligations go which way. And if you do that, which is often very smart, and may create a lot less friction, by the way, you can avoid a lot of expenses. That may be what you have to do in this situation if everybody, can't agree. Then you've got a problem.
Well, how about the other side where the roots get carried away and they start tearing up your driveway, your foundation, and then is it reasonable? I would argue that it's reasonable. What if there are already damages and you find out your neighbor's tree has roots that have come up?
I have a case like that right now, and I think you can probably sue for the cost of replacing the driveway and get permission to cut the roots, whether it kills the tree or not. But again, to be safe, you'd want to go to court. You wouldn't want to have a wonderful lawyer like me who's not a judge telling you which way it goes. Because again, you're looking at fact specific. And one judge's view of what's reasonable may be another judge's view of what's unreasonable. So you're better off getting a judge to put something in writing and go with that. But that's a good question. And I have exactly that case now where roots are tearing up somebody's floor. And the other side won't let them cut the roots. They say, you can't go on my land even to cut the roots because the tree is very close to, it would be hard to.
Another real extreme is how about bamboo? Roots get under and they start tearing up they can get into a pool and even if you cut them, they're going to grow back the next year. So.
Yeah, big issue. And so that's the kind of thing, I think again, it would be reasonable to say you could cut the thing and do anything you want even if the tree dies. But you're faced with the fuzzy wuzzy issue. And that's where we are.
So you're better off working out an investment. How do you work it out? So you have two reasonable people, and they come to, okay, let's work this out. You shake hands. Handshakes are great amongst friends, but it's not something that you can pass on to the next person.
It falls into something I always tell colleagues like you that, in my experience, which is unfortunate, I would love to make a living just by writing agreements for people and getting them together. And then I'd have a nice steady income. My experience is my income is very unsteady because I'm constantly doing emergency surgery. People don't have an agreement or they have a handshake. And then later on there's a big question of what they agreed to. And we end up with a lawsuit.
Right.
Of course, the best thing is have a handshake and then back it up in writing.
And maybe do it before it becomes a problem.
Yeah.
Same with the fence. Go out and say, okay, well, let's agree in writing that we're going to keep this fence here or something. Or
yeah, I would say, again, my favorite kind of work, basically my favorite clients are people who come to me ahead of time, and we try to work something out. And if the other side agrees, that's great. If you get an attorney who tries to have the same philosophy as I do, we work things out. I have to tell you, when you get into court, if it's a good judge, first of all, most judges today, they want to do a good job, they're ethical, but they really want to get this problem off their desk. And what the judge will almost always say to you as you're moving toward trial is, why can't you work this out? They really don't want to sit through a trial.
Well, don't they kind of demand to go to mediation before anyway?
Yeah, but mediation isn't, you can go into mediation, but that doesn't mean you have to have an agreement.
Right.
But judges urge you to. And a judge I once heard, which I really liked, I liked what he said, was he said, you have a lawsuit, the only people that are going to come out ahead are Steve Gaynor, and then he mentioned the other lawyer.
Right, yeah.
And the other thing he said, which was really quite interesting, was he said, he says, if you make me have a decision after a trial, none of you are going to be happy. So even though you're mad at each other and all that, why don't you go outside and make an agreement that you each feel you can live with, because you really will be unhappy with me. It was a great remark.
Yeah,
and
yeah.
It's a
reasonable remark.
Yeah, and I think people who know what they're doing, as even in a lawsuit, really realize they should do that.
Recognize that as the bell.
Well, because you can be so creative when you're trying to work things out. In other words, you don't even have to stick with this tree. You can sit down and say, by the way, if you leave my tree alone, we'll put something down so the roots can't bother you, and I'll pay for your doghouse.
Yeah.
All kinds of things that a judge would have no power to order. All kinds of things you could do. And so, that's the point. You leave my tree alone and you've always been worried about your swimming pool, I'll kick in some money for your swimming pool. Just amazingly creative things where everybody ends up happy. So if the lawyers are creative and the neighbors are creative, it's a great way to do that. So that's a good idea. To write an agreement, you want a lawyer. It's not that somebody like me has to use a bunch of gobbledygook and buzzwords, but a lawyer who's used to writing agreements is to some extent a historian. They know what went wrong in the past with agreements, so they know what to write now.
Cover the what ifs.
The what ifs. They've read books of people fighting over all things that weren't covered last time.
What do they call it? This isn't the first rodeo.
Yeah. And so that's a reason to hire a lawyer for almost any contract, is that lawyers, if they're experienced and they have gray hair or not much hair, already have a good idea of all the things that went wrong in the past with agreements or not having agreements. And, those things come in, and it's very important. And I'm amazed how many people write agreements by themselves, and they just don't cover everything that finally comes up. They miss it totally.
So, hopefully that answered some of your questions, gave you questions, some information to be more prepared with your real estate trees, your fences. And Steve, almost a pleasure. hang out.
I mentioned one more thing.
Okay, please, yeah.
The magic term when you sue on almost all these things, the unhappy neighbor, is nuisance. You end up coming in and saying the tree is a nuisance, the fence is a nuisance. That's just the magic word. So the particular claim in the lawsuit is a suit for nuisance. That's the magic word. There's all kinds of nuisances, and we're not going to talk about those today. It could be your poodle that barks all night. But nuisance is the broad term that everybody uses that comes in finally when they finally say, I don't like your tree.
And that is an actionable.
Oh yeah, nuisance.
And there are damages, and you can prove it, and it's okay.
Yeah.
There are awards given. And
Now the other side, when whose tree was damaged, that's just that's damages.
Right.
That's injury to my property. But those are kind of the fancy lawyers' words that finally go in there. That takes care of that.
Okay. Thanks. Thank you for watching.